Seniors, listen closely. The Social Security Administration is testing a new tracking device that could one day determine whether your benefits continue or stop completely. This isn't science fiction. It's already in pilot programs, and you need to know how it works, who it affects, and what you can do to protect yourself. Before we get into the details, like subscribe, and tell me in the comments if you think the government has gone too far, because what I'm about to tell you could change everything for millions of retirees. Part 1. The device you haven't heard about. Most seniors believe the SSA tracks them in only a few simple ways: through your bank deposits, your yearly cost of living paperwork, maybe a letter or two if they need verification. But here's the truth. In the last few years, several agencies have started experimenting with devices that can follow your location, track your physical movement, and in some cases, even monitor your daily habits. These devices can look innocent: a medical alert bracelet, a smart wristband, a fall detector you hang around your neck, or even a phone app that's disguised as a safety check system. The marketing pitch is always positive. We're protecting seniors from falls. We're keeping loved ones connected. We're making sure emergency services can find you. But in reality, that same device can log exactly where you go when you go there, how long you stay, and even how active you are. This information is stored, and in some pilot programs, it's already being reviewed to see if a senior's activity matches the medical limitations they've claimed for benefits. Let me give you an example. If a device shows you climbing stairs every day for 30 minutes, but your disability claim says you can't climb stairs without pain, that's a potential red flag. If the data shows you spent 2 weeks in another country without notifying the SSA, that could also be flagged as a violation of benefit rules. The scary part? You might think this is all hypothetical, but it's already been tested in small programs involving seniors in certain housing or disability assistance plans. Part 2. Why this could affect your benefits. You might be wondering, but I'm not doing anything wrong, so why would I care? Here's the problem. The SSA is constantly reviewing whether people still meet eligibility requirements for benefits, especially when it comes to SSI, Supplemental Security Income, and SSDI, Social Security Disability Insurance. In the past, those reviews meant sending forms, gathering doctor's notes, and sometimes going through a re-exam. It was paperwork heavy, slow, and often incomplete. From the SSA's perspective, a tracking device is instant, automatic, and requires no cooperation from you once it's on your wrist or in your home. If you're receiving disability benefits, the agency could theoretically look at your daily movement to see if it lines up with your claimed limitations. Example, if you've been approved for SSDI because of severe back issues and your device logs you walking 3 miles every other day, the SSA could interpret that as evidence your condition has improved, even if you were simply having a rare good week or pushing through pain. It's not just disability benefits, either. For certain benefits, like SSI, leaving the U.S. for more than 30 consecutive days can stop your payments. If your device pings outside the country, that's a red flag. The issue here isn't that technology is evil, it's that data is often taken out of context. A single spike in activity could lead to questions could lead to an investigation, and investigations can lead to benefits being suspended or stopped. Part 3. Pilot programs and real cases. Some people think I'm exaggerating when I talk about these programs. I'm not. Let me explain how it's already being used in other contexts, because that's usually where we see the test runs before it becomes more widespread. In some rehabilitation and parole programs, participants are already required to wear GPS ankle monitors to verify their location at all times. That's not new. But what is new is the crossover into health and insurance programs. Some private disability insurance companies have already rolled out phone-based GPS checks and activity challenge wristbands, and if you refuse to wear them, they sometimes treat it as noncompliance. Here's a real documented case. A man receiving private disability payments claimed he could barely leave the house due to severe anxiety. His insurer provided him with a smartphone check-in system that quietly recorded his movements. After several months, they noticed he was traveling to a park nearly every day. He said it was his coping method, but the insurer argued it proved he could leave home and interact with the public, and they cut his payments. That case is still being fought in court, but it shows exactly how location and activity data can be used as evidence to challenge your claim. And here's where seniors need to pay attention. What starts in the private sector often moves into government programs. Once the infrastructure is there, it's relatively simple for the SSA to say, if you receive benefits and we've given you a device for your safety, we'll also use it to confirm your eligibility. Part 4. The privacy loophole. Now, a lot of seniors tell me, well, they can't just track me without my permission. That's illegal. And yes, generally speaking, the government can't simply slap a tracking device on you without cause. But there's a massive loophole: consent through benefit programs. If you agree to use a free device provided by the SSA, a Medicaid program, or even a local aging services office, you may be signing away more privacy than you realize. Hidden in the fine print of many device agreements is language like, you consent to the collection and storage of activity data. Data may be shared with authorized third parties. Information may be used to verify eligibility for benefit programs. That means the moment you agree, you've essentially volunteered your information. And in court, it's extremely hard to argue that your rights were violated because you signed or clicked accept. The legal term here is informed consent, but the problem is most people aren't actually informed. The terms are buried in 10 pages of legal jargon, and you're often told the device is purely for your safety. By the time you realize it's being used to monitor you for eligibility purposes, it's too late. Part 5. Who is most at risk? It's important to understand that not every senior is going to wake up tomorrow and find a government-issued tracking device in their mailbox. This is rolling out quietly, and it's starting with very specific groups. And this is the key, once a group becomes the testing ground, expansion happens much faster than people expect. Here's who's most at risk right now. 1. Seniors receiving disability benefits, SSDI or SSI. If you're on disability, your eligibility is based on your ability to work or perform certain activities. These benefits are already subject to regular review, which means you're in the highest risk category for new monitoring technology. 2. Seniors in government-funded housing programs. Some public housing complexes for seniors are experimenting with safety systems that monitor movement in common areas and even track when residents enter or leave their apartments. At first, this data might be used to detect falls or emergencies, but in theory, it could also be shared with agencies overseeing your benefits. 3. Those using free or subsidized medical devices. Fall detectors, home health monitors, and GPS-enabled wandering prevention devices for seniors with memory loss are all incredibly helpful tools. But many are funded by Medicaid, state aging agencies, or nonprofit groups partnered with the government. If you receive one through an official program, there's a strong chance that data is stored and possibly accessible to other agencies. 4. Seniors in rural areas receiving special health access programs. Certain rural health programs already require participants to wear or use tracking-enabled devices for data collection purposes. While the goal is often to improve services, this still means there's a record of where you are and when something that could be used in ways you didn't anticipate. The bottom line, if your benefits depend on you staying within certain limits, whether it's where you live, how much you travel, or what activities you can do, you should be very cautious about any device that collects data about your life. Part 6. Legal protections you still have. Now, I don't want you to walk away feeling completely powerless, because that's not true. Even if these tracking programs expand, seniors do still have rights, And in some cases, the law can absolutely be on your side. First, the SSA and other agencies must follow due process before cutting off your benefits. That means they have to notify you, explain why they're taking action, and give you a chance to respond. Second, you can challenge the evidence they're using, and that includes GPS or biometric data. You can argue that it was inaccurate, incomplete, or taken out of context. For example, if your tracker showed you walking long distances, you can submit medical records showing you were in physical therapy or pushing through pain under doctor supervision. Third, data collection without your consent is still subject to legal challenges, especially if the data being collected is unrelated to the purpose of your benefits. That means if you never agreed to the monitoring in writing, there's a legal opening to fight it. The problem? Most seniors don't know these rights until after their benefits are already suspended. And once benefits are stopped, you can be left without income for months while you fight your case, even if you eventually win. The key takeaway is this: don't wait until it happens. Learn your rights now, keep written records, and be ready to respond quickly if you're flagged. Part 7, what you should do now. This is the part most seniors overlook, taking action before you become part of a tracking program. Here's what I recommend to my clients. 1. Read the fine print twice. Before accepting any device or service from a government program, Medicaid, Medicare, or a nonprofit connected to these agencies, look for any mention of data collection, location tracking, or information sharing. 2. Ask direct questions. Don't just ask, "Is this safe?" Instead, say, "What information does this collect? Who has access to that data? Can the SSA see it?" If the person can't give you a clear answer, that's a red flag. 3. Document your health regularly. If you're on disability, make sure your doctor's notes clearly match your real activity level. If you have occasional good days, have that documented too. So if tracking data ever shows you being active, it won't automatically be used against you. 4. Keep personal control where possible. If you want a medical alert device, consider buying your own privately rather than accepting one through a government program. That way, you can choose a provider that doesn't share data with outside agencies. 5. Stay informed. Technology changes quickly, and privacy laws often lag behind. Make it a habit to read trustworthy senior news sources or legal updates, so you're never caught off guard by a new program or policy.